has been incorporated, it's time to look at intellectual property. Paul Matthews, who's a partner with Lawson Lundell LLP, is here with us to describe the ins and outs of what you should be considering as you move forward with your venture. If your innovation has been developed in a lab or as part of your research with the University of British Columbia, you will need to consult with the UILO office to understand what part of that research is the property of the university. And we will be doing a VODcast on that topic with Derek Gratz separately. For this program, we're going to delve into the issues around intellectual property that has been developed outside of the university. I'd like to start, Paul, and have you describe a little bit about your background and also Lawson Lundell. You started out as as a practicing engineer, is that correct?
Hi, Camille. Yes, that's right. I started my career as a process and research and development engineer in the oil and gas industry, and have been back and forth between engineering and law throughout the course of my career. As you may know, Lawson Lundell is a full-service business law firm. We have offices in Vancouver, Kelowna, Yellowknife, and Calgary, and I'm a member of the technology group at Lawson Lundell. My practice is focused on technology commercialization, and that covers the IP strategy, which is really about defining your intellectual property assets and your commercialization pathways, followed by technology development and commercialization. My practice spans all 4 offices and is broken down roughly now about 1/3 industrial technology and 2/3 digital technology. On the digital technology side, a good portion of my practice is devoted to digital security and privacy.
So to delve in, intellectual property, it's a term that actually encompasses many different types of creative assets. Can you describe for us what the term really means?
I'll put my spin on it, Camille, and that is that intellectual property is really the creations of the mind. And it's creations that are recognized at law, either by specific statute or the common law, which is judge-made law. And these are distinguished as intangible assets. Compare those to tangible, which we refer to as bricks and mortar assets. They can, it's important to note, be used or exploited in a similar fashion as bricks and mortar assets in that they can be transferred, they can be sold, they can be passed through an estate. You can use them as security for a loan as well, just to name a few examples.
So can you give us a couple of examples of technology that you've protected recently, just to give the audience who are pretty new to this field a sense of what we're talking about?
Sure. So I'll start perhaps with industrial technology. And industrial technology covers the gamut from large pieces of equipment to finite ways of testing materials or molecules in a lab. So for example, in industrial technology, I've been involved in strategizing the capture of intellectual property assets as it relates to specific mining methodologies with unique or innovative pieces of equipment. In the digital technology sector, software is primarily the asset that drives the economics and the commercialization there. And I've been involved in a number of copyright matters with respect to digital technology and software, domain names and how those support a web-enabled business in its branding and marketing exercises is another one. And trade secrets, interestingly enough, it's been a bit of a boomer year for me in the past year. capturing trade secrets and licensing those out. And that can be anything from certain methodologies for performing calculations, various data sets that have been collected, and the analytics that you apply on those and the learnings that come out of them.
That's really helpful because for many businesses, there are multiple areas that they can and should consider protecting, and you've covered them really beautifully there. When I look at valuation of a business, and this is talked about a great deal, especially as companies begin to talk to investors, in my experience, the bulk of the value of a company is actually the intellectual property. Can you talk a little bit about that?
Well, certainly in the startup space, for technology-based startups, it may in fact be the only asset that the organization has is the intellectual property. And so that's really one of the primary criteria that investors and others are looking at and assessing in terms of deciding how or if they will invest in the organization or support it.
For our teams, which very much fit into that rubric that you are describing, if IP is a critical part of their value, they should really be considering the protection of the IP and the strategy around the IP as part of their business plan, not simply as an exercise to go through with a law firm. Can you talk about what you would recommend to them in thinking about IP in that fashion, in that strategic fashion?
Well, sure. There's a number of considerations that really start with, number one, doing an IP inventory. Know what your intellectual property assets are. I think your second step then is to really understand, given those being your assets, how do those support your business strategy? Because we know from many past dealings with startups and mature companies that an intellectual property asset, just for the sake of having that asset, quickly becomes a stranded one and a cost center as opposed to something that supports the business strategy, which is all about driving competitive advantage and preferably having it associated with a revenue stream. So know what you've got, know how it supports your strategy, know how you're protecting it. Make sure your team knows that, have your workflows, your processes, your training in place, and enforce it or don't. Again, that's part of your strategy, understanding the value, how it supports, and how you are going to leverage it to drive your business strategy.
Many of our teams are completely new to this concept of intellectual property or IP. Can you walk us through how IP protection is granted?
Well, certainly. So it really depends on the nature of the intellectual property asset, but the underlying commonality here is that intellectual property are assets that are recognized at law. So it's really about finding the statute that spells out the steps for protecting. And I think what we're really talking about is capturing. Protection, to me, relates to the enforcement of your asset from being exploited by a third party and the impact that may have on your business, whether it's lost revenue, lost reputation, or other. So I prefer to use the term capture, and it's really about finding the legislation or the parts of the common law that speak to that. So for example, in Canada, we have a Patent Act, Copyright Act, Trademark Act. Trade secrets are recognized at common law, so that's something that you won't find an act on, which is quite different than the way it's treated in the US, where they have a Uniform Trade Secret Act. So that's where I would suggest everyone look.
We use the term IP, but this actually covers quite a range of types of creative ideas. Paul, can you take a crack at walking us through the different forms of protection for the different types of IP?
Well, sure. Recognizing that it's really just a very light touch on all of these. If we look at the suite of laws that we have in Canada for capturing intellectual property, we have for inventions, and that's a term that can cover pieces of equipment, it can cover methods, it can cover chemical molecules, it can cover those aspects that are defined in the Patent Act as being patentable. What it does not cover are ideas or abstract theorems. So there's patent protection for that. For branding items such as logos, names that are related to products or services, we have trademarks, and both trademarks and patents are the subject of an application, a review by our government agents under the Canadian Intellectual Property Office, and then following the satisfaction of the criteria in that review, the asset is issued or granted. We have copyrights under our Copyright Act, which can cover music, drama, literary works, and those are created and recognize that law upon their creation. So there's no formalization step that's necessary. There's a very important additional right that comes with copyright, and that's something that we call moral rights here in Canada. And then the last would be trade secret, which is a subset of confidential information. That's recognized at common law. And certainly, unlike the states where they have a Uniform Trade Secret Act, here we have a three-part test that really boils down to the notion that the subject matter of the trade secret drives or retains commercial value by virtue of it being secret, and it is the subject of reasonable efforts to protect its secrecy.
You have a wonderful example about the Ford Mustang and the different types of intellectual property within that vehicle and the different methodologies that you've just described that were used to protect those different aspects of the vehicle. Could you use that as a bit of an illustrative method of further explaining what you've been describing?
Well, sure. So I'll start with perhaps what really jumps out for me when I think about a Mustang. It's the horse logo that's found right in the front grille. So that would be the subject of a trademark, that's a logo or brand. If we think about the process of actually designing that particular vehicle, we can imagine that there are a series of drawings that were essential for the design, and those drawings would have copyright in them. We know that there's an airbag system to meet our safety regulations in Canada, and we also know that the airbags in the Mustang have been the subject of a patent. So that's a nice way of sort of looking at one product that's quite familiar to us and being able to see that there are numerous opportunities for capturing and creating intellectual property assets and using those to really drive a revenue stream.
One of the areas that's complex and costly around patent protection is the idea of jurisdictions and what's actually covered and the rationale behind all of that structure. Can you walk us through a little bit of that?
Well, sure. So patents are really a creation by our government for the purpose, ostensibly, of disseminating knowledge. So there's a quid pro quo that's at play with the government, and that is that in exchange for disclosing your innovation, your idea, and publishing that, making it available to the public in a way that it advances the state of the knowledge in our society, the government will give you an exclusive monopoly for that technology, that invention, in the form of a patent. So you have to disclose your knowledge in a way that it can advance the state of the knowledge in society in exchange for that monopoly. the rights that are associated with a patent are exclusive, and they encompass the right to use the invention, the right to make or have the invention made, and the right to sell the invention. So quite a bundle of sticks there. With the patent, the hammer that you have as a patent owner is really to, we'll take a product as an example, is really to look at an infringer, and your legal remedies are that you can shut the infringer down from pursuing or continuing the infringing activity, have the infringer deliver up all infringing products, or have them disgorge all of the profits that they have received in selling that infringing product. So you can see that that's a tremendous enforcement hammer for you in the marketplace. There is quite a bit of strategy, however, in, for example, pursuing a patent. And some call it the stick and carrot strategy, where the stick, of course, is the patent you have the ability to enforce, and the carrot is that perhaps there are aspects of the patent, of the subject matter in the patent, that haven't been disclosed, and that help someone taking that technology or that invention and optimizing it. And so having some technical knowledge, some know-how, and being able to license that as well is somewhat of a carrot and stick strategy.
Can you describe what a patent database search actually tells you and what it doesn't tell you, most importantly?
Sure. So when I think about that question, there are four important facets that come to mind. So the first is really looking at the technical requirements for patentability. So when we talk about the database, what we're really talking about is something that's coined as prior art. What technical information is out in the public domain, whether it's literature or other patents, that are relevant to the venture's invention. This goes to the legal test for patentability, and I'm not going to go into the elements there, frankly, because I find that too often in talking about the test for patentability, too many engineers in particular, but inventors self-select and offer up defenses, if you will, or rationalizations for not pursuing patent protection with beliefs such as it's just good engineering practice, or it's just my job and what I do. So in terms of the test for patentability, in that, that first sort of threshold question is, do you have something that's patentable? I would say suspend your disbelief. And if the solution that you have has commercial value, there is certainly something in the intellectual property space that we can use to further your business objectives and presumably a revenue generating stream. So that's the first part is the technical requirements for patentability by looking at what we call the prior art landscape. The second really is equally important, and that's market intelligence. Lets you know who's active in the space. It should give you some appreciation for what their technology development trajectories or pathways are. It should also perhaps indicate to you, depending on how far you do your searching, how invested they are in their technology or their inventions, how much they're spending, whether they have a purely offensive or a defensive strategy in terms of their protection. So lots of good information there. It will tell you who else is in the space, whether it's a crowded space and there's a lot going on. And this is all important in understanding where there is an opportunity for you to stake out your claim for your invention, staying away from places where there's overlap, or perhaps going into places where there's overlap, again, with the right strategy and thinking. I guess I'd like to close with the thought that looking at the technology landscape, if you will, the patent database, it's as important to consider that exercise as part of the innovation process. what it does is it shows you what other solutions have been tried to your problem and should be an opportunity for the inventors to stress their own appreciation for the solution that they've developed and perhaps evolve that understanding or evolve their solution.
So what does IP protection not give you?
Well, I'll just carry on with the patent example. And what it doesn't provide is the commitment, the resources, whether it's people, money, or other, to actually enforce. The obligation, or the right, if you will, is on the intellectual property holder to enforce their patent rights. No one else is going to do it for you. So you really have to think carefully in contemplating enforcement as to whether the size of the prize is big enough to warrant the investment and the burden. And certainly in the patent space, where you have your research and development team or your inventors, and you're taking them off of developing new products and generating revenue opportunities for you and putting them into an infringement action, there's really quite a cost associated with it.
What should these teams be thinking about as they bring on employees and contractors in regards to protecting their intellectual property and ensuring that they're buttoned up so that they don't end up at a time when they have few resources in a situation where they have to make the kind of choice that you're describing?
Well, when I hear that question, Camille, what I immediately think of is a common misperception that because someone is paying for the creation of what might be an intellectual property asset, that payment equals ownership. And we know that that's just not the case at all. For example, we'll talk about patents. And the default is that an employee owns the intellectual property, the inventions that they create, unless there's an express or an implied contract that provides otherwise. A great example of this is the Calgary Park Plus debacle that appeared a number of years ago, where some City of Calgary employees were involved in the creation of the automated parking system in Calgary, and they retained or attempted to retain the inventors' rights to that. I believe they even filed a couple of patent applications in their own name and not in the city's name. And so that really created a cost and put significant delay on the city's then vision to look to leverage that innovation and license it for some revenue. And if we look at copyright, we know that copyright is owned by the author. However, the author is not a defined term in the Copyright Act. So the default is that if the copyright is created by an employee in the course of performing their job, then that is owned by the employer. The rub here goes to working with contractors and consultants, and the default is that the contractor will own all intellectual property. So if you have a developer that's creating code for you, they actually own the intellectual property, the copyright in that code, and the moral rights, unless it's expressly assigned in writing by the contractor to the party that paid for the work. So the message here really is, number one, just because you pay for it doesn't mean you have ownership. And number two, it's best practice, and I would say essential, to ensure that you have ownership rights with all of the appropriate assignments in place, not only in the employment context, but with all of the contractors and subs that you have working with you.
So let's say you're the City of Calgary, or you're one of our ventures, and you run into one of these situations. You've got employees or a contractor that have violated an agreement, or a competitor has violated the agreement. What do you do to enforce, or what rights do you have to enforce your intellectual property rights if you've protected them appropriately?
Well, and really what we're talking about is, if we're talking about enforcement, we're talking about a legal solution to a business problem. And my preference is always to find a way to get the business teams to come together. Hopefully rational minds will prevail and a business solution can be worked out where perhaps the lawyers come in and put the appropriate protections in place so that that can be implemented. With the appropriate contracts and the appropriate assignments in place, you really are put to the task of putting the other party on notice that they have overstepped their rights and are violating yours. And if you can't come to terms with that party, you're really stuck with going down to the courthouse and getting a third party that doesn't know you, doesn't know your business, and certainly doesn't know your intellectual property to decide the outcome of what your dispute may be and how the spoils are going to be split up. You know, if we go back to one of our previous conversations, which was around, you know, what are the remedies for patent infringement? Well, there's, you know, the equitable remedy of injunction to stop the infringer from infringing. There's the remedy of delivery up or destruction of the products. You can imagine that the court does not move as fast as business. You can imagine that, again, this is a distraction and this is a significant cost. So I would really encourage the ventures or the owners of the intellectual property to really know what intellectual property they have, know the value of it to the business strategy and its contribution to generating revenue or other competitive advantage, and in that context, making a rational decision as to what sort of effort they're going to put into enforcing it. There's always the flip side to not doing anything, in that you may in fact be telegraphing to the marketplace that you're not open for business, that anybody can do that. So that's really a huge caution. But there's also some legal principles at play that if you sit on your rights and don't enforce them, that it may preclude you or prevent you from enforcing them in the future. So lots of considerations, all of them, depending on the value or the contribution of the intellectual property to the business, all of them, you know, points that really should be considered right up front when the venture is really getting set up with its governance, setting its processes, strategies in place so that it's all, you know, really clear.
You know, I've seen situations where companies have done this extremely well and, you know, have ended up as a competitive strategy being taken to court to delay them raising funds and slow them down, and have been successful over time in winning. Companies that have had their IP stolen in China and have been able to hire the police and the detectives to sort it all out and have successful outcomes. So I think being buttoned up, if you're serious about your business, being buttoned up is vital as a business strategy. I think you've described some of the rationale extremely well.
Copyright is not an idea. Copyright is the tangible expression of an idea. So it's that tangible expression that is the intellectual property asset. As we said before, copyright arises upon creation. There's nothing that needs to be done to formalize the existence of that right or the ownership of that right. There is an opportunity in Canada to register your copyright. That, however, it does not tactically factor into your ability to enforce it. There may be strategic reasons and practical reasons that you should do that. If we compare that to the States, where you actually have to register your copyright in order to enforce it, we can see that if you're looking at the North American market for any copyright as part of your business, then you have to be aware of the copyright scheme in both jurisdictions, and they are different.
Trademarks. Can you tell us what a trademark is and give us some examples?
Well, sure. So a trademark is a word or group of words or image that identifies the party providing the services or the products as the source of those products or services in the mind of the consumer. So we talked about the example of the Mustang logo on the front fender of Ford's iconic Mustang. I don't think that there's much more by way of introduction to say other than that.
So one of the reasons I asked the question is many of our teams develop a name and a logo, and they might go through 3 or 4 different names and logos as they go through the program, but they often don't think to check and see if either of those are protectable. And then when it's time to go to market and they sit down with you, they realize that some work needed to have been done to lock up what they were planning, and that they might have to let go of something that they cared about because somebody else is using it or it's used in another related industry. So I think it's helpful to just talk a little bit about what these folks should be thinking about as they choose a name. And it could be a working name, and maybe it's not important until they actually go through the process of incorporating and then locking things up. But if it's something they're really invested in and they really want to see as part of their eventual venture, what they should be thinking about.
And that's a conversation that we routinely have quite early on in a venture's formation. The prospect of creating a name, creating a logo, having an identity in the marketplace, one that the team is usually quite proud of and identifies with, is interestingly usually a conversation that we have before we talk about other types of intellectual property assets. And the conversation really needs to be around a branding strategy. It's not enough to look at names and think about that before you really invest in it. And the investment takes a lot of different facets, if you will, or a lot of different forms. It's everything from, the money in your branding to your materials, to the cost for a graphic designer for the logo. You should really understand what's out there in the marketplace. If you go to the Canadian Intellectual Property Office website, you can look at the database for trademarks, and that will at least give you an idea of what's registered. It won't give you anything because there still are marks that are being used with common law rights. Another thing it won't give you is, and this is interestingly quite important as well, is the purchase of your domain name. So including your domain name in that strategy is quite important, and to lock that down at the same time will save you a significant amount of potentially a significant amount of pain and cost for the purpose of avoiding cyber squatting. We have a nice side business going on challenging cyber squatters, if you will, through Canada's process, their domain name dispute process. We find lately in Canada that upon the application of registration for a trade name, there are those that are watching for those applications and go out immediately and buy up domain names for the prospect of exploiting or extorting the owner of that trademark at a future date for the domain name. So it's more than just the name. There's quite a scope to that conversation, and domain names, frankly, are quite inexpensive. Usually you can get a bucket of them for $100. So I would really encourage the ventures to give that a broad and thorough consideration.
I'm so glad that you brought that up. It takes about 5 minutes to protect a domain name, and I can't tell you how many teams I've sat down with who are out actually in the marketplace creating pilots and doing user testing of their minimum viable product, and they have not locked up that domain. So I'm glad you raised that. Trade secrets. Can you talk to us a little bit about trade secrets?
Well, sure. So trade secrets, as we said earlier, is a subset of confidential information. The point of distinction is that trade secrets derive their economic or commercial value by virtue of being secret. Typical examples, and these are consumer examples, are recipes like Coca-Cola or Kentucky Fried Chicken. but I can certainly attest to the notion that trade secrets are also calculations, methods, data sets in databases, molecular compositions. It really can span quite a broad range of assets that drive commercial value.
Last area I'd like to cover is confidentiality. We touched on this briefly when we talked about employees and contractors. As our teams move to the end of the program, they begin to focus on strategic partnerships. They're bringing on team members. They are talking to angel investors, venture capitalists, grant funders, and they begin to be interested in getting NDAs signed, and some parties will sign them and some won't. Can you talk about that piece of being prepared as a business and what the factors are?
So that's, confidentiality is quite a conversation. And a couple of considerations for ventures embarking on these formative introductions, networking discussions. The first is to really recognize that the best protection for information that provides you with a competitive or commercial advantage is to keep it confidential. Don't disclose it. Top of mind for teams should be managing their disclosures of confidential information. Consider first whether a disclosure of confidential information is actually necessary to further the discussion or the business opportunity that is present, or will non-confidential disclosures suffice? Where a disclosure of confidential information is essential, really the point there again is to still manage that disclosure to limit the amount of information that is actually disclosed. Second, where it is essential and you have to disclose information of value, put a non-disclosure agreement in place to provide a basis for aligning your interests with the counterparty. And the alignment is clarity on what you consider confidential and what is important to you, and for the other party as well. This agreement also provides an evidentiary basis for enforcing protection of your confidential information and obtaining remedies in the event of a breach of the duties of restricted use and confidentiality. Now, you mentioned that given the startup community and the way it operates, there are some investors that won't sign these sorts of agreements. And that's correct. I wouldn't say that it's all of them, but many do. And an example, certainly in this community, is the Valhalla Angels. They simply won't sign an NDA as a matter of practicality. They are dealing with so many entrepreneurs that to have to accept the burden of signing, administering, and managing their affairs in accordance with what could be hundreds of these agreements just doesn't make any sense. That doesn't mean, however, that you can't protect yourself. The best thing in that sort of circumstance is, number one, to put the other party on notice that the information to be disclosed is confidential. Say, for example, you're about to give a pitch. Declare that at the beginning of the pitch or conversation. To the extent that you're using materials to further or illustrate that conversation or support it, have a stamp on those materials that is conspicuous, identifying it as confidential, particularly if you're going to be leaving a copy behind or distributing one. And keep a record of the date, the time, the identity of the recipients of the confidential information, and what confidential information was disclosed, just so that you've got clarity on managing that pool of confidential information. In this way, you may not have a written agreement, but you certainly have set up yourself with an evidentiary basis under the common law for protecting your confidential information.